There are two matters to be listed in orders column in any date, Lordship. One RSA, one RFA
Give detail.
for service report and
Okay.
obliged.
May I please, Your Lordship? I beg to mention item number 8, my lord.
Ah,
Can this matter be taken some other day, my lord? NDPS
number
matter,
8.
my lord.
Council Mr. D. Bora has prayed for adjournment. Please the matter after, list the matter dated at the date give a bail.
February দিলে obliged, my lord.
May I please, Lord?
Ah, yes,
Okay.
yes.
I beg to mention for listing one RSA Lordship.
Mm.
12 of February Lordship.
For what?
Hearing column Lordship.
Hearing not possible on 12th of February.
Then Lordship 17.
17 fine days.
Deeply obliged Lordship.
Okay. May I please, Lordship?
Mm.
Lordship, I beg to mention item number 4. Lordship, kindly adjourn the matter for a week.
Item number,
4.
Learned Council Mr.
B. Fukon, D. Boru on behalf of Mr. B. Fukon.
D. Borua.
Yes.
On behalf of Learned Council, Mr. B. Fukan has prayed for adjournment. List the matter after
1 week.
1 week.
May I please, Your Lordship? Your Lordship, I beg to mention for listing an RSA matter on the hearing column any date on the month last week of February or first week of March. First or second week of March. Can it be a earlier date, Lordship? 10 months.
Lordship, I beg to mention old CRP matter which is pending for hearing.
Hmm.
On our last occasion, it was fixed for top of the list, but unfortunately, it was deferred. Any date?
Okay, we'll fix it on top of the list dated at the hearing garden. Ona case.
Much of it.
List this, it top of the list বুলি কৈ দিলে হৈ যাব। নাই নাই ডিকটেশন তাতে কৈ দিলে হৈ যাব top of the list বুলি।
Much of it.
May please, Your Lordship.
Huh? You note down on your mention memo. As top of the list.
May please, Your Lordship.
Mm.
I beg to mention item number 10, my lord. May be taken on Tuesday, my lord. 10 to my lord.
Tuesday.
Yes, my lord.
Fine, 10 Tuesday.
Tuesday, my lord.
Bail hearing, okay.
Yes, my lord. Next Tuesday, 10. Item number 10. Item number 10 may be taken on 10, my lord.
As requested by the learned counsel for the petitioner, list this matter on Tuesday ki tarikh?
10 to.
My lord, item 6, my lord, it is fixed today, my lord. As directed, we have filed the additional affidavit. Inadvertently, it has not been tagged with the record. Let a requisition may be issued.
May it please, Your Lordship. Your Lordship, I beg to mention listing of 3 MFA. All the MFAs are at the hearing stage records. Can it be listed on the first week of March? 19 March. 3. Okay.
Analogous matters.
Yes, Lord. Okay.
Please, Your Lordship. Lordship, I beg to mention for listing of a RFA for withdrawal on Monday, Your Lordship.
For withdrawal.
Withdrawal. Oblige, Your Lordship.
Wait, please, Your Lordship.
Lordship, since the matter, they have already appeared, the sole respondent has appeared, they have also filed their affidavit. It may fix for admission. Of course.
Only one respondent.
Only one respondent.
Learned counsel, Mr. B.J. Mukherjee is present for the petitioner. Learned counsel, Miss
FIBA Nag.
E. Brahmo.
FIBA F. Oh, Austin Nursery. I'm on behalf of senior.
Miss
FIBA.
Miss A. Nazari.
Yes.
A. Nazari on behalf of learned counsel, Mr.
FIBA F.
FIBA what?
FIBA Nag. NAG Nag.
F Nag on behalf of A Nursery.
Can we listen after?
উল্টাকে লিখিব লাগিব নেকি? Is present. List this matter in the admission column. We'll call for the trial court records. Final order. You have come against final order.
Final order.
Meanwhile, call for the trial court records only.
Yes.
Meanwhile, call for the trial court records.
Your Lordship, after 13th of this month. Yes.
I have not given any date
Yes.
in the admission column after 2 weeks then, after 2 weeks or 3 weeks?
After 3 weeks then.
After
3
3 weeks.
weeks, yes. No trouble. Thank you.
My lord, in a land acquisition proceedings,
Hmm.
the petitioner was in adverse possession of 17 lakhs of land. So out of that, my lord, 16 lakhs has been acquired by the government,
Mm.
the National Highway Authority, Act,
Mm.
and the other in respect of 2 katha, 1 lakh,
Mm.
suit is pending. So therefore, when they have taken over the land under the land acquisition proceedings,
Mm.
my lord, they have determined the value at 4 lakh some amount rupees.
Mm.
And ultimately, the matter went to district judge, additional district judge. And what he has found is page 60, 61. Only his view has been expressed here that only owner is entitled to get the compensation. Other person interested are not entitled to get the compensation. This is the view expressed by him at page 60.
Mm.
And if your lordship goes into the National Highway Act 3G,
Mm.
3G, even the Fair Compensation Act is also applicable. 3G, if your lordship goes into, where the land is acquired under this act, there shall be paid an amount which shall be determined by an order of the competent authority. My lord, your lordship got it?
Mm.
3G. Then 3G2, where the right of user or any right in the nature of easement. So user, easement, any land is acquired under this act, there shall be paid an amount to the owner and any other person whose rights of enjoyment in that land has been affected in any manner whatsoever by reason of such acquisition. So right of user, right person interested, rights are also respected. So therefore, the conclusion of the land judge that only the owners are entitled to get, that is on the face of it in violation of the rule.
So now what do you want me to do?
Your lordship will kindly issue notice. In the meantime, my lord, stay the order part.
Let me see the order. Which part you are agreed of?
I'm agreed of this.
Page 60, 61.
Page 55, page 60.
Please read the paragraph.
Yeah, I'm reading the relevant paragraph. Here, one party is claiming on the basis of the adverse position, and the other party is claiming over the basis of the recorded patta owner. Paragraph 23. Then paragraph 24 says Amar Datta, the petitioner, right, title and interest over the scheduled land on account of adverse position maintained by him, any from the leading contention of the parties. It is quite clear that the whole issue certainly requires full-fledged trial to establish their claim over the land in question. It appears that while dealing with the land reference case, this forum does not adjudicate such disputed fact. Therefore, in my considered opinion, the prayer may herein is not maintainable, and in my considered opinion, the Amarchand being not the owner is not entitled to get benefit in terms of acquisition proceedings initiated by competent authority come additional deputy commissioner Jora. Now your lords will kindly see the land lot Mandal's report. Page 33, madam. This is the Mandal's report, madam. Last paragraph. Upon conducting a field investigation today, page 33, upon conducting a field investigation today, in the presence of Sri Rumi Borua, Sri Amar Datta and other local person, it was found that Sri Amar Datta has constructed a Pakka house on joint land measuring 1 katha 2 letters covered by Dak number 30364 under the aforesaid periodic patta and a part of land measuring 16 letters covered by Dak number 809. So I am admittedly I am in possession of the land, and in respect of the other land, I was in total possession of 2 katha 17 lacha. 16 lachas of land, they have acquired it. I am entitled to get the benefit of this.
This has been taken, considered by the court?
Yes, yes.
Where, in which paragraph of the judgment?
Lot Mandal's report. Lot Mandal report, my lord, they have not taken into consideration. They are saying, my lord, they are the owner, that particular paragraph.
No, but how
only
can they
the owner.
consider the Lot Mandal
Lot
report
Mandal,
here?
I'm just
It was
saying.
report a court. And if the court has considered or not in the judgment,
No, I'm trying to find. But it is admitted that I am in possession of these two kathas, 17.
Lot Mandal's report is necessary.
Lot Mandal report, they have not taken into consideration. Everything was there. We have filed a total.
That rejected part of the judgment is sufficient.
Hello?
In which part of the judgment that
Hello, I'll-
report was rejected?
Well, Lot Mandal has not been discussed.
Hmm?
Not been discussed. But only on the.
Then we'll need the LCR
LCR review.
to find out if Lot Mandal's
Yes,
report
yes.
was submitted.
Yes.
What do you want me to state?
Well, for the time being, this, the order positive should not be given effect. For the time being, if they come and if they, file application for vacating, that should be decided. Otherwise, this petition will become effective. I can show judge then that how it is, the person who uses it.
Where in the judgment it has been admitted?
Hello?
Which witnesses have admitted that they are occupying the
They
land?
have taken in the witnesses and all, and they've taken, the landed additional district has decided on the basis of the plea.
Oh, okay, okay.
But admittedly, he has accepted.
Where is the, this will be a reference from this district, from the DC.
From the DC to the.
Where is the petition? Where is your petition?
I have given a written statement, my lord. Title suit. My lord, record will prove that.
You have not annexed your written statement.
Written statement, we have, in the, that is in regard to title suit we have given. For, my lord, page 29. Is the.
No,
petition-
title suit written statement is not required. I'm asking.
In LA, we have 5, page 29.
In the LA?
Page
Page
20.
29. Let's see.
Page 20.
This is Doug number
809.
PP number 45 and Doug number 809.
89, yes.
And you are?
I'm 809.
Hmm?
I'm 809.
What is your name? Omar Dutta.
Amar Dutta.
Yes, written statement. Please read the written statement.
Hello?
Please read the written statement.
This one. That the petitioner has been residing in the subject land covered by Doug number 809, PP number so and so. Jorat, Assam, which has been requisitioned by the concerning revenue authority at Jorat for the purpose of extension of lane, 4 lane. The petitioner in the meantime has received the compensation of structure thereon without any objection from any quarter. But the compensation as assessed in respect of the land is not yet released due to objection raised by the respondent. Several conciliation has been made in reference of the parties, but the concerning land requisition officer could not settle the dispute and referred the same to the district judge to this court for adjudication. That this petitioner admittedly has been under occupation of the land covered by Dag number so and so of Pumwa Gao.
You have not mentioned
Moja,
about the
Assam.
Mondel's report here also.
My lord,
You have not mentioned about the Mondel's report.
Mondel's report I think in this petition I have not mentioned, but it
Yeah.
is in, to my
Let us
understanding.
call
it
for the
is-
LCR.
Yes, Lord.
We will not stay anything.
But in the, it should not.
No, but there's a title suit pending.
That, so that is in respect of 2 Katha 1 lot, sir.
Hmm.
This is what I am trying to say is that total land in occupation of the petitioner was 2 Katha 70.
Okay, all right.
For the timing, your lordship.
Third learned counsel, Mr. B.D. Das,
Assisted by H. Roy.
assisted by learned counsel, Mr. H.R. Das. For the petitioner Omar Datta. Omar Datta is the petitioner.
Yes,
Omar Chandra Datta,
yes.
who is aggrieved by the judgment dated 21/11/2025 passed by the learned additional district judge Jorhat in LA case number LA within bracket ref case number 7/2022 under section 3 capital H within bracket figure 4 of the National Highways Act 1956 denying entitlement of the petitioner to receive compensation for acquisition of land at measuring 16 lechas out of 2 Katha 17 lechas covered by PP number 45, Dag number 809 of Pamua Bhokot Gaon of Khongia Moja Jorat. Full stop. It is submitted on behalf of the petitioner that the learned court has urged in law as under section 3G. 3G of the NH Act 1956, an occupier of the land is also entitled to possession. It is submitted that the petitioner has claimed his right, title, and interest over the land acquired by the government of Assam,
Yes, ma'am.
by the government. of
National
Assam.
Highway Authority, madam.
Huh?
National
By the
Highway
National Highways Authority. By the National Highways Authority.
Which is. What is-
On the basis of adverse possession by the petitioner, which was in the knowledge of the respondent, the respondent has raised objection during the release of fund and the petitioner is unable to obtain the compensation which was apportioned in favor of the petitioner, full stop. It appears that the operation of the impugned judgment and order may be stayed, full stop. Thereby, the operation of the impugned judgment and order dated 21/11/2025 passed by the learned additional district judge in LA case number 7/2022 is stayed till the next date of listing. Meanwhile, call for the trial court records. List the matter on date of the video.
I'll take steps by registered post and the. normal
Steps may be taken by registered post, no, registered post, speed post.
Speed post.
Now is speed post, speed post as well as by usual process. Usual process
Yes.
and speed post, okay.
Right.
Mm.
In this case, lordship, petitioners are the defendants, lordship, in the title suit which was filed by the respondent, lordship. Before that, lordship, this is the third litigation, lordship. Before that, the first suit was filed by one Manik Chandra Burman, that is annexure 1, page 14, lordship. Against the petitioners, lordship. This is Srimati Torubala Burman and others, lordship. This suit was for right title interest and recovery of possession. That was, lordship, dismissed. So Manik Chandra Burman lost his title suit 26 of 2009, but thereafter there was no title appeal, no regular second appeal, and no SLP also.
26 of 2009.
Nine,
26
yeah, lordship.
month.
It was filed by Manik Chandra Burman against the present petitioners, lordship.
He lost the suit.
He lost
Suit
the
was
suit.
decreed in favor of the petitioner in which year?
No, lordship, it was dismissed.
Oh,
He is the plaintiff. So suit
dismissed.
was
So it
dismissed
was in favor of the petitioner.
in favor of
He
the
was in
petitioner.
favor of the petitioner.
Yes, lordship. At that relevant point of time, we are possessing the lands, and Manik Chandra, lordship, filed the suit for right title interest and recovery of possession, lordship. After, lordship, the dismissal of the suit, Manik Chandra Burman, with the help of another person, dispossessed us. So we filed a suit that is 29/2011, annexure 2, lordship.
This annexure to page
31, lordship. That suit was under section 6 of the specific relief act only for possession, lordship, recovery of possession. As he already lost his title suit for right title interest, right title already in our favor, lordship. We are from the same family of the plaintiff, lordship, the Manik Chandra Burman. So only the suit was for
Same
recovery
family.
of possession, section 6 specific relief act. Yes, lordship. Then page annexure 3, page 49 is the petition filed by the
for right title and interest.
no, lordship, only recovery
No,
of
no.
possession.
Only recovery of possession.
Only recovery, section 6 suit,
Okay,
lordship.
okay, only.
Then, lordship, annexure 3, page 49. The defendants filed a petition under order 23, rule 1 to withdraw their title appeal. As only on the wrong advice, they have filed title appeal. So they filed this application praying that paragraph 4, lordship, that it is submitted that due to mistake on the part of the lawyer, the appeal is filed instead of revision. So there was a title appeal that was withdrawn by them, lordship. This is the page 49, your lordship, for a moment. Paragraph 4, that it is submitted that due to mistake on the part of the lawyer, the appeal is filed instead of revision. The appellants are laymen and they do not know the pros and cons of the legal provisions and are dependent upon the lawyer. As such, they may allow to withdraw the instant appeal. Thereafter, lordship, the order was
No,
passed.
no, why against that order appeal will lie? Why it will not
No,
lie?
section 6, lordship, civil revision
Okay,
will
okay.
lie. There is no provision for appeal, lordship. So the appeal was withdrawn, annexure 4, page 51, lordship.
Page
51, lordship. Their title appeal 4/2013.
This is what? Page 51?
51 is the order passed in their withdrawal petition, lordship.
Okay, okay, okay.
Seen the petition under order 23, rule 1 of CPC, read with section 151 of the CPC filed by the appellant side for withdrawal of the appeal. It is stated in the petition that instant appeal is preferred on being aggrieved and dissatisfied with the order, judgment and decree passed in title suit number 29/2011 on 16/8/2012 by the learned Munshi Bongaigaon as per provision of section 6 of specific rules, specific relief act, lordship. It is submitted that due to mistake on the part of the lawyer, the appeal is filed instead of revision and prayed to allow the appellants to withdraw the instant appeal with a leave to file a revision before the Honorable High Court, peruse the record, heard both sides, considering the facts and circumstances and having regard to law, the appellant is allowed to withdraw the appeal. So their title appeal was withdrawn and thereafter they filed civil revision petition, that is page 53. That civil revision is also dismissed, lordship. Relevant portions are in page 54, Lordship. Order dated 29/4/2015 by this High Court. Their civil revision petition was dismissed, Lordship. Last paragraph, Lordship, and the same is accordingly dismissed, Lordship. Thereafter, they filed SLP before the Honorable Supreme Court, and the SLP order I have enclosed annexure, Lordship, 6, page 58.
Let me read the order of this court.
This court, Lordship, that is. May I read from the original, Lordship? Type
Yes.
copy I have given, page 56 is the original. Lordship. I have
Yes.
considered the rival submission and noticed that the finding at the trial judge is based on relevant evidence. Moreover, the submission of the petitioners on title not being valid can be an acceptable ground for challenging a decree of restoration of possession under the specific relief act. Since no perversity or jurisdictional error is noticed with the impugned decision, this revision is held to be without merit and the same is accordingly dismissed.
Okay.
So Manik Chandra and Jainal Abedin lost in civil revision petition also. Their name is there, Lordship, page 53, Manik Chandra Burman and Jainal Abedin. Original is page 55, Lordship, Manik Chandra Burman and Jainal Abedin. So they lost in the civil revision petition. Thereafter, SLP was filed, page 58. And Lordship will find Manik Chandra Burman and another. So Jainal Abedin was there also, Lordship. Against Torubala Burman, that is the present petitioners, Lordship. Since the suit under section 6 of the Specific Relief Act is based only on the issue as to whether the plaintiff was dispossessed within 6 months from the date of institution of the suit, having regard to the finding recorded by the courts, we, without going into other questions raised by the petitioners, do not find any reason to interfere with the impugned order. The special leave petition is accordingly dismissed. So Jainal Abedin and Manik Chandra lost in all the courts in our Lordship Specific Relief Act suit, Lordship. So decree attained finality. Thereafter, Jainal Abedin filed a petition before the executing court, Lordship. We have filed execution case for recovery of possession, Lordship. Page 59, Annexure 7, Lordship. Before SLP is dismissed, Lordship, he filed this petition saying that my SLP is pending. No, Lordship, after SLP, Lordship, paragraph 2, that the Honorable Supreme Court admitted the SLP white number SLP so and after hearing passed an order on 24/7/2015 with an observation that since the proceeding initiated by the decree holder are under section 6 of Specific Relief Act is based only on the issue as to whether the plaintiff was dispossessed within 6 months from the date of institution of the suit. However, question of title has not been decided and as such the Honorable Supreme Court did not interfere with the impugned order and consequently the SLP has been dismissed. The certified copy of the order has been received through DTDC courier services on so and so. So the number paragraph 3, Lordship, that the judgment debtor Mohammad Jainal Abedin has constructed tin sheet houses on the decretal land and he had the reasonable belief that SLP may be succeeded before the Honorable Supreme Court and such he did not make arrangement to remove the houses standing on the decretal land meanwhile, that in the event of execution of the decree by dismantling the standing houses on the decretal land, there may be irreparable monetary loss to the judgment debtor number 2. As such, he prays that he may be allowed to vacate the decretal land by removing the standing structure. So this petition was allowed. Thereafter, again, he filed a petition, Lordship. This petition was filed on 14/8 and immediately after 6 days, he filed a petition on 28, that is Annexure 8, page 61. Now, Lordship, he stated that in paragraph 3 that on 18/8/2015, the judgment debtor number 2 filed a suit by title suit number 100/15 against the decree holders before the Honorable District Judge Chirang or declaration that order judgment dated 12/2012 passed in title suit 2911. Lordship, that is the judgment in section 6 specific relief act suit, Lordship, which attained finality by the Honorable Munshi Bongaigaon was fraudulently obtained. So this is his Lordship pleading that we have obtained the judgment fraudulently, Lordship. And decree for right title interest and confirmation of possession over the decree
At
till
page
then,
61, no?
page 61, Lordship. And
Which-
confirmation of
which page
possession,
are you reading?
there are 3, Lordship.
Okay. Yes, I got it, yes.
Lordship. So his allegation is that section 6 specific relief act judgment was obtained by fraudulently by the petitioner's Lordship. On that basis, he filed a title suit that is 100/2015. And I have shown your Lordship that he already contested the title appeal, CRP, SLP, all the matters he contested, Lordship. Now, on this allegation, he filed a suit that is title suit 100/15. And after filing of this petition, Lordship, our execution proceeding has been stayed by the executing court, as because in the meantime, he obtained injunction in the present title suit, Lordship. So execution proceeding was stayed by the learned executing court. That order also I have enclosed, Lordship. Page, annexure 9, page 65. Page 66, relevant portion. Hence, keeping in view all the above mentioned proceeding is stayed for the time being till dispose of the proceeding in the court of Honorable District and Session Judge Chirang. So till disposal of the title suit filed by Jainal Abedin, Lordship. The Nazir is directed to inform all the concerned, page 66, Lordship. The Nazir is directed to inform all the concerned to stay the execution as steps has already been taken for execution of the said decree. So Lordship, execution proceeding already stayed in the present title suit. We appeared and filed our written statement. Plaint of the present title suit I have enclosed annexure 10. Written statement we have submitted, that is annexure 11, Lordship, page 82. In this petition, Lordship, we have filed one petition for cross-examination of the PWs. There are some lacuna on the part of the petitioners, but Lordship, due to all the petitioners are ladies, Lordship, there was no male member to advise, and there was absence of proper advice from the side of the other parties also, Lordship. So they could not cross-examine the PWs of the present suit, which was filed by the Jainal Abedin on the allegation that we have obtained the decree fraudulently, Lordship. So it is utmost requirement of the petitioners to cross-examine the PWs and adduce their Lordship evidence. I have enclosed all the documents along with my CRPIO only because that Lordship, to satisfy your Lordship that already he contested the section 6 suit. Thereafter on a false.
Now you are coming against which case? Now you are.
Third case, Lordship. First case, Manik Chandra lost. Second case, we, Lordship, won the
You are coming against the execution case or you are coming against the
title suit, Lordship. Filed by Jainal Abedin. We have filed one application.
What do you want in the title suit?
Title, we want to cross-examine the PWs, Lordship.
You are not allowed to cross-examine?
No, Lordship. There are some opportunities were granted. Lordship, the plaintiff could not cross-examine.
Let me see the date, orders.
103, Lordship. Relevant portion 104, second paragraph, upon the perusal of the record.
Where is the order where you were not allowed to cross-examine?
Lordship, that is page 103.
Please read the order.
It's a very long order, Lordship. Page 104, second paragraph I am reading, upon the perusal of the record.
104, okay.
Yes, Lordship.
Yes.
It appears that on 22/3/22, the suit was fixed for cross-examination of PW1, and on the said date, the defendant side was absent without any step, and accordingly, the cross-examination of the PW1 was dispensed with by my learned predecessor, and the suit was fixed for cross-examination of PW2 on 6/4/22. On 6/4/22, again, the defendant was absent without step, due to which the cross-examination of PW2 was dispensed with and the suit was fixed for cross-examination of PW3 on 28/4/2022. Thereafter, on 28/4/2022, the defendant side was represented and the defendant side prayed for adjournment and the suit was fixed for cross-examination of PW3 on 30/5/22. On the subsequent dates, that is 13/5/22 and 1/6/23, again adjournments were sought by the defendant side for the cross-examination of PW3 and the adjournments were granted to them. Thereafter, the suit was fixed for cross-examination of the PW3 on 14/7/22. However, on the said date, the defendant side was absent without any step, and again the suit was fixed for cross-examination of PW3. Lordship may see on next part. By
Sufficient time is granted.
Yes, Lordship.
So whose fault is it? It is
Lordship.
your fault only.
If Lordship, the petitioners were not allowed, Lordship, they will be deprived of Lordship after some.
After some time, yeah.
Lordship. That's why I'm saying for time being, my lord. Time being, my lord.
Okay.
Very timely. Additional affidavit plan. Follow question.
So.
Lordship, please come in. Kindly pass over the matter for time.
Okay, all right.
In this case, my lord, I am appearing on behalf of the respondents, my lord, Union of India, represented by the General Manager, Northwestern Railway, Jaipur, Rajasthan, my lord. So, as per direction of the Honorable Court, the order dated 18/12/2025, they are directed to file an amended appeal. And accordingly, they filed the amended appeal, and I have received this copy, my lord. So, in this case, in earlier appeal also, I filed counter affidavit. Since they filed the amended appeal, my lord, again, I have to file the counter affidavit in this case.
Appellant is not represented today.
It's not in the court.
He's not present.
Yes, sir.
Learned standing counsel.
I'm the special senior railway advocate.
Learned special senior
Railway
railway
advocate.
advocate is youth property is present and has submitted that they will file a counter
Counter
affidavit
affidavit to the amended appeal.
against the amended appeal.
Yes, my lord.
List this matter after 4 weeks.
No, my lord,
2 weeks.
because I have to prepare it, I have to send it to the concerned authority of the Northwestern Railway, Rajasthan, Jaipur. 6 weeks time may be granted, my lord.
Okay, list this
6.
matter after 6 weeks.
Bless your lordship.
Maybe to lot. This is a regular fast appeal, madam. My claim has been rejected, madam. The rejection order is at page 32, madam.
Claim has been rejected.
Yes, madam.
So what to do? We'll issue notice?
Yes, madam.
Issue note, learned counsel, Mr. S.B. Das.
SP Das. SP Das.
SP Das is present for the appellant. First of appellant to take steps to issue notice to how many respondents?
The one that was, madam.
To respondent returnable
One.
within respondent returnable within 4 weeks?
Madam, 4 weeks, madam.
list according.
Records.
Okay. Records, plain only.
Yes, ma'am. Let me call.
Plain.
Yes, ma'am. It has been written on the first day, madam.
Will not need records.
Madam.
It's only a plain.
Yes, ma'am. Plain. Obvious.
Item 9 CS submitted also.
Lord,
Transcript submitted. Yes.
I am praying for only one observation, my lord, that the petitioner will approach before the learned court below and his bail petition, he'll prepare a bail petition that will be considered as per law, my lord. That much
Yes.
observation.
Learned Counsel, Mr. Z. Hamad.
Yes, my lord.
Mr. Z. Hamad is present for the petitioner. Full Learned Edition PP Mr. P.S. Lofer has submitted the charge sheet has been laid against the petitioner. Full stop.
Height
The
CS number 30,
being CS number.
height
liquidation.
CS number 34/25 dated 24/7/25.
You are on interim bail.
No, my lord.
The petitioner is at liberty to approach the jurisdictional court stroke Aleka magistrate and apply for this, which may be considered by the court in accordance with you.
Deeply blessed.
You can approach later also when notices will be issued.
Yes, my lord.
Mm.
Lord, it is a shoot for a specific performance. Lord, there was agreement for sale. It was written by scribe, my lord, SPW2. And attesting witness were examined as 3 and 4. What happened in the case, my lord, that the defendant number 1, my lord, and 2 jointly filed written statement. After filing the written statement, my lord, they did not come forward for contesting the case, my lord. So, my lord, even we adduce evidence 2, 3, 4 in support of my case. They were not cross-examined even. And ultimately, my lord, the courts below dismissed my suit. So I have formulated some substantial question of law, my lord. First one is this, my lord, this appellate court take recourse to section 72 of the BNS, my lord, BNS of this Bharatiya Saksho
এখন দিয়াচোন BNS খন
BSA অধিনিয়ম।
BNS আৰু CPC খন দিবা হা।
Section 72, your lordship may look into. Section 72.
No, এইটো নহয় ভাৰতীয় স্বাক্ষৰ এভিডেন্স এখন এইটো এভিডেন্স
New act, my lord.
নতুন এভিডেন্স
অধিনিয়ম।
সাক্ষ্য BS what is it?
My lord.
BSA BNS BSA হয়
BSA ভারতীয় সাক্ষ্য অধিনিয়ম 23 এই নতুন কিতাব।
BSA খন ভিতৰতো থাকিব নালাগে চাই তিনিটা এক একেলগে আছে মেজৰ এক বুলি নতুনকে তিনিটা মেজৰ এক নতুনকে আছে সেই তাত ওলাব Where is the judgment of the appellate court?
My lord.
Page. This orders
Page, my lord, to page 12.
concurrent decisions or reversal order.
My lord.
Concurrent decisions or reversal order.
Concurrent.
Concurrent decisions.
Concurrent.
Where is page? Which page? Judgment of
Page-
the appellate court,
Judgment starts from page 12, my lord.
appellate courts.
Yes, my lord. So, my lord, your lordship can skip.
Page 12.
It starts from page 12, my lord.
Please sit down, I'll read the judgment.
My lord. PW, my lord, discussed at page 22.
No, I'll read it.
My lord.
I'll need to read it.
My lord.
নহয় নহয় এই এখন ফকত কিতাপ এখন দিছিলে মাজতে লাইব্ৰেৰীৰ পৰা তিনটা মেজৰ এক্ট BNS BSA আৰু BNSS তিনটা একেলগে আছে শকত কিতাপখন তাত ওলাই যাব I think I have gone through this.
My lord, yes.
Then
Your lord-
why are you coming again?
And your lordship,
Why you have to go to this court again?
though it is not recorded in the order, my lord.
Ah,
But your lordship said that after going through the judgment, your lordship will pass the order. That was not passed. I have taken time,
you know why I didn't pass the order?
my lord, yes. What happened, my lord? When I.
When I
matter.
go through the RSA, এইটো
My lord.
streaming to off কৰি দিয়াচোন এই আৰ্গুমেন্ট খিনি থাকক তাতে Yes.
My lord, I am appealing on behalf of the petitioner, my lord.
Mm.
On 4th February, this matter was partly heard, my lord,
Mm.
and this
I don't remember actually.
this
I have
court
got this matter, maybe I do not remember. Yes.
yes, this court was pleased to direct to file additional affidavit to produce the rest of the medical documents, my lord. And we by way of additional affidavit for which we have filed and it has been packed with the record, my lord. In this case, my lord, this is this revision was filed challenging the impugned order, my lord, on 11/24 passed by the learned MSCT2. By the said order, the claimant widow was permitted to withdraw only rupees.
Oh, yes, yes, that,
Yes, madam.
that there was a capping.
Yes, madam.
So you have any objection? No, I think so. We can pass an order. What is your ground now?
My lord,
Urgent need of money for treatment of your son.
yes, my lord.
Which paragraph of your petition?
Petition, my lord, in paragraph, my lord. In paragraph, my lord, 10, my lord.
Paragraph 10. Learned counsel, Mr.
VK Jain.
DK Jain is present for the petitioner, Regina, alias Regina Maui, and 3 others petitioners above. And learned counsel, Miss Arguswamy.
M. Psychiatrist.
M. Sokia is present for the insurance company.
Yes, Lordship.
Full stop. It is submitted by the learned counsel for the petitioner that this revision petition is preferred against the judgment and order dated 27/4/2018.
My lord, against the order, my lord, order dated, my lord, the impugned order, my lord, it is in page number 72 to 73, my lord. Annexure 4, my lord, the copy to impugned order, my lord. Whereby the London Tribunal is directed to release only 50,000, my lord. Out
Page
of-
number?
Page number, my lord, 72 to 73, my lord.
Against
Annexure 4, my lord, of the revision petition, my lord.
Annexure 4. Against the impugned order dated 11/11.
Yes, my lord.
Page number 72.
Page number 72, my lord. Annexure 4, my lord.
Against the impugned order dated 11/11/2024, passed by the member MSCT number 2, Kamrup Metro, in connection with MSC case number 541 of 2009. The petitioner had prayed by petition number 8751 dated 25/10/2024 with prayer to release the fixed deposit amount of rupees 2 lakhs each in 14 accounts. 14 accounts.
There are 14 numbers of FDR of rupees 2 lakhs each, my lord, and one FDR is 80,000.
In 14 accounts and one fixed deposit of rupees 80,000.
80,000, 15, my lord. 80,015.
Which tantamounts to a total of rupees 28 lakhs 80,015. Full stop. It was also ordered that the fixed deposit, that the amount of entire amount of rupees 28,80,015 is to be fixed for 15 years in the various accounts, in the various fixed deposit accounts, in the name of the petitioner number
1, my lord.
1, stroke claimant number 1, Regina Maui. Full stop. The learned member of the MSCT, however, did not allow the petition, and by partly allowing the prayer, pass an order to withdraw an amount of only rupees 50,000.
Yes, my lord. 50,000.
Only rupees 50,000 in her name. From the FDR receipt number 152869. And the remaining amount was directed to be kept as fixed deposit in the name of the petitioner. Full stop. At present, it is submitted that the petitioner has prayed for withdrawal of the entire amount owing to the change of circumstances. Full stop. The petitioner's son is suffering from what ailment? How old is he?
Hello. In para 8.
Para 8 of your petition?
Yes, my lord. In page number 11, my lord.
The petitioner's son, who is petitioner number 3, is suffering from chronic tuberculosis, pleural PLURAL effusion, coupled with pleural PLURAL EFFUSION effusion, coupled with pleural EMPYEMA, with other severe multiple ailments for several years. First of, he is undergoing regular treatment in different hospitals. First of, recently, he underwent medical treatment at Mata Chanan Devi Hospital in New Delhi on 5/4/2024, 15/4/2024, 29/4/2024, and 13/5/2024. Full stop. Later, he underwent treatment for his ailment at Deen Dayal Upadhyay Hospital, New Delhi on 28/5/2024. Full stop. He also underwent further specialist treatment at the Max Healthcare at Saket, New Delhi on 18/7/2024 and 23/7/2024. Full stop. An additional affidavit has been filed with the documents of treatment undertaken by Solomon, Mr. Solomon, 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 Lal, LAL, MAL, SAW, MA at Max Hospital, and he has been referred
For thoracic surgeon, my lord.
Where is the referral order?
In annexure 8, my lord, of additional affidavit. He has been advised, my lord.
And he
refer
has
to
been
thoracic
referred by annexure. By annexure 8 to thoracic surgeon. Full stop. Entire treatment requires he requires sufficient entire treatment. The entire treatment requires sufficient funds as the petition had to bear the expenses of the treatment of her son. Full stop. The earlier order was passed by the MACT on 27/4/2018 in MSC case number 541 of 2009, awarding the compensation on account of death of the petitioner number one's husband in a motor vehicular accident. Husband? Petitioner
ma'am.
number one's husband
Yes, ma'am.
in a motor vehicular accident. Full stop. It is submitted that this is that the compensation was awarded under a beneficial legislation, and if the petitioner is not allowed to withdraw the amount fixed in her account for treatment of her son, the petitioner will be highly prejudiced even after the judgment was passed. Judgment and even after the judgment and award was passed in her favor. To stop, the learned counsel for the insurance company has no objection. The petition is filed under Article 227 of the Constitution of India, read with Section 115, Sections 115 and 151 of the Code of Civil Procedure. Considering all aspects and for the interest of justice, the order dated 11/11/2024 is set aside so far as the direction to the petitioner to withdraw, so far as the order to the petitioner to withdraw only 50,000 from a fixed deposit accounts is concerned. Full stop. Only that much I'll set aside.
Yes.
The order is modified, set aside now, is modified, is modified. The petitioner is directed the petitioner is hereby allowed to withdraw the entire amount of rupees 2880,015, which has been kept as fixed deposits.
My lord, it should be during pendency of this proceeding, my lord. 2 lakhs has been released. 50,000 was earlier released as per the award MSAT order, my lord. Subsequently, 1,50,000 was released by the bank on being maturity. So 26. Now it is 26,018, my lord.
26,000.
My lord, 26,30,015, my lord. 2 lakhs has been released, madam.
Okay, 26,30,000.
26,30,15.
26,30,50 is allowed to withdraw the entire amount of rupees 26,30,015,
015.
which have been kept in different fixed deposit accounts in the name of the petitioner.
Yes, madam. Along with the accumulated interest there, no? Bank will
That
release.
you will get, interest you will get. In terms of the above observation, this petition stands disposed of. Place this. Oh.
Lordship, as for this
Oh, yes.
order, Lordship, on 2-3 dates, they were given chance for each of the PWs, one date were given and they could not remain present on that date, on that.
And you consider the PWs together?
Lordship,
One date,
I
how
am,
many dates?
Lordship, I am praying before your Lordship, only allow us to cross-examine all the witnesses in one date, Lordship. If your Lordship allows only one date on that date, if they fails to.
You have any authority?
Yes, Lordship, this is a case where this is a suit for specific performance of contract where defendant could not contest after issue of notice, Lordship. Thereafter, at the execution stage, Lordship, he was allowed by the Supreme Court to go back to the trial court and to consider contest the
Cross-examination.
paragraph 7 is relevant, Lordship. Paragraph 7, Lordship.
Yes.
Ordinarily, litigation is based on adjudication on the merits of the contentions of the parties. Litigation should not be terminated by default, either of the plaintiff or of the defendant. The cause of justice does require that as far as possible adjudication be done on merits. The disputed agreement is dated so-and-so, summons was issued and it was received but according to the appellant by his mother. The trial court has apparently accepted the case of the appellant that the mother did not bring the receipt of the summons to the notice of the appellant and that it was sometime in June 2014 that the appellant can be credited with knowledge of the suit. The order dated so-and-so as follows, Lordship, and thereafter paragraph 9 order further appears to reveal that the plaintiff was present in person. The plaintiff has filed his proof affidavit. It was decided to proceed against the appellant ex parte. There is, however, a reference to the application to engage an advocate by the appellant. The case stood posted for ex parte argument on so-and-so. As parties were not present on the said day, the case was posted to so-and-so. However, on so-and-so, the case stood transferred to another court. No intimation was given under Rule 89A to the appellant. The further case of the appellant is that he came to know from the plaintiff that the case was fixed for judgment on 17/11/2015. He has alleged that he contacted his counsel, but he did not get a satisfactory reply. He also has a case that he appeared on 17/11/2015 in court, and then he only came to know that judgment was rendered on 9/10/2014. A new counsel was engaged on 26/11/15. Thereafter, the application was filed. One fact stands out, and that is that the appellant came to be served notice of the execution proceeding. So when the execution started, Lordship, then his case was considered, Lordship. And from this, we have seen that in the year 2014, notice was served and Supreme Court allowed in the year 2019. So my humble prayer before your lordship, only one date may be given. They will cross-examine all the witnesses. Lordship.
Without their objection,
Lordship.
without their objection.
Lordship, only one chance may be given, Lordship. On that date, there may be, the trial court may fix a specific date. On that date, all the witnesses may be brought by the plaintiff and we'll cross-examine, Lordship. Because Lordship, official witness was cross-examined only on February 2025. I have enclosed the cross-examination. Page 93, Lordship,
It's not
Annex
required.
30. And their Lordship, their prayer to call the official witness in the year 2022. That petition also I have enclosed, Lordship. They
No, it's
prayed,
not required. I'll go through the order and I'll go through the judgment.
Lordship.
Just a moment. I'll go through it and then I'll pass
Lordship.
the orders.
My case is that, Lordship, due to the fault of the petitioners, there is no delay, Lordship. Maybe there are some, no specific advice was given to the petitioners to contest the title suit, Lordship. They were pursuing their title execution, Lordship. So,
Yes, yes. I'll keep that in mind.
Lordship,
If I forget, you just remind me while
Lordship.
dictating.
Lordship,
I'll just go through the order and the judgment of the Supreme Court and I'll pass the order.
Lordship.
Ms. R. Chaudhary, counsel for the petitioners, Srimati Torubala Burman, Elias Srimati Torulota Burman, Kavita Burman, and Dipti Burman. We stop. It is submitted on behalf of the petitioners that after three failed title suits being brought up, three failed litigations being brought up by the respondent and his respondent and his companion. What is his name?
Manik Chandra Burman.
And his companion Manik Chandra Burman, the respondent Mohammad Zainal Abedin has brought up a false litigation registered as TS number
32/2021.
32
/2021.
2021 against the plaintiffs. Full stop. The plaintiffs are owner and occupiers of the suit land, and they, after successfully obtaining a decree, they are pursuing the execution case. Full stop. The defendants went up to the Supreme Court, and their prayers have and their case have not been accepted, have been rejected by the SLP, no?
Yes.
SLP number how much? Was rejected by the
19707/2015, page 58.
SLP 19707 /2015
15
was rejected by the Supreme Court
on 24/7/2015.
on 24/7/2015,
15. So the section 6.
which they had preferred against the plaintiffs under Section 6 of the Specific Relief Act,
Yes, Lordship, against the judgment 18/7/2012.
which they have preferred against the
16/8/2012.
plaintiffs লিখে দিলে হবে, Section 6 নামাই plaintiffs, full stop. After being successful in the, after getting an order in their favor, the plaintiffs were pursuing the title execution case number
01/2015.
full stop. The defendants have falsely alleged that the plaintiffs have fabricated forged documents and are in possession of the suit land, and the defendants are pursuing the title suit number 32/2021 with such false allegations. Full stop. During trial, the plaintiffs have failed to cross-examine the plaintiffs, no, the petitioners.
Defendant.
The petitioners have failed to cross-examine, the petitioners as defendants have failed to cross-examine the plaintiffs' witnesses in TS number 32/2021. Full stop.
Lordship, bracket, it may be recorded as title suit number 102/2015. Earlier it was 102/2015.
Old TS number, এনেকে লিখি দিবা, TS number 102/2015 old লিখি দিবা, bracket close. When the plaintiffs were debarred from cross-examine, when the plaintiffs, now when the defendants, when the petitioners as defendants were debarred from cross-examining the plaintiffs' witnesses, they preferred, they filed a petition number 873/2023, which was registered as Midje case number 59/2022. Full stop. The trial court, however, rejected their petition to cross-examine the plaintiffs' witnesses PW 1, 2, and 3.
Yes, Lordship.
PW 1, 2, and 3. Full stop. The relevant part of the order is extracted herein below verbatim. Itu page following the plan page 103, order dated 12/3/2024. Itu heri tick mark di disu, moi double tick mark di disu. Page 104. Continue korba gori kini ha, page 104. One 105. One 106. 106 और मैं double tick mark di thudju, tap close kori diba. Next para likha. It is submitted on behalf of the plaintiffs, that plaintiffs and petitioners, that they were contesting the title suit, and they are willing to contest the title suit. Full stop. Being women And what did you say?
Lordship, they
Repeat
have
it.
changed advocate also. In the petition
Oh.
itself, they mentioned that change of advocate is also. Being layman, Lordship.
Being laymen, the petitioners did not get proper advice. Post up, they also changed they also appointed a new engaged counsel to represent them in the title suit. Post up, the plaintiffs ought not to suffer for the negligence of the lawyer. Okay.
Petitioners, Lordship.
Or the petitioners ought not to, plaintiffs, the petitioners ought not to suffer for the negligence of the lawyers. Anything else to be noted down?
Lordship, they are already the decree holder. The fruits of the decree they will to
The
Lordship.
plaintiffs will be deprived from
Petitioners
the
are already,
fruits of the decree. As the petitioners will be deprived from the fruits of the decree as they are the decree holder after being
Contesting
successful in 3 litigations.
Lordship.
In 3 litigations which have been brought against them by the
No, that was
No,
the
they have
suit filed by us.
in 3 successive litigations. Post of the- Considering the submissions at the bar, it appears that a last opportunity may be accorded to the plaintiffs petitioners to cross-examine the plaintiff's witnesses.
Lordship, it will be better to say plaintiff witnesses as because the official witness has been numbered as PW5. So maybe there are 4 or 3 in the order reflects there
Plaintiff
are.
witnesses to cross-examine the
Or
plaintiff's
earlier, your
witnesses.
Lordship has stated.
Yeah,
that
I have
Lordship.
mentioned as plaintiff's witnesses only.
Lordship.
Petitioners to cross-examine the plaintiff's witnesses. I have also considered the submission that on one date, the cross-examination will be completed by the plaintiffs,
Lordship.
thereby for the interest of justice, the petitioners are allowed to cross-examine all the petitioners' witnesses,
Plaintiff's witnesses.
all the plaintiff's witnesses within 1 month.
Lordship.
Do you have a date fixed?
Lordship, or within 1 month or Lordship, any date. Lordship, first I have to brought notice of
yes.
this order before the
Yes,
learner
yes.
trial.
In
but
1
then
month from the date of this order.
Lordship. And to cross-examine the plaintiff witnesses and to adduce evidences because in the meantime suit proceeded to argument stage, Lordship. Though the PW5 was cross-examined on 2025.
Nice.
Lordship.
Plaintiff witnesses cross-examine the plaintiff's
Lordship.
witnesses.
And to adduce,
Official witnesses are also there.
Lordship.
In terms of the above observation, this application stands disposed of. Oh, এইটো এটা judgment সোমাই দিয়া তো ক'বাত সোমাই দিবা হা কোনোবা এটা আগত ক'বাত সোমাই দিবা. The petitioners have relied on the decision of the Honorable Supreme Court in Robin Thapa versus Rohit Dora, reported in 2019 7 SCC, wherein it has been held that paragraph 8, 9, 10 or 11.
Obliged, Lordship.
Okay, I'll dispose it with a cost, I think.
Lordship.
Huh?
Lordship.
1,000 rupees
No.
with
Before the learner trial court, Lordship.
with a call disposed of directing the petitioners to dispose of with cost of rupees 1,000 to be paid by the petitioners in the before the trial court.
Lordship. Obliged.
To be deposited by the petitioner in the trial court.
Item number 5. Hey, your Lordship. My lord, as such, in this application, there is no impugned order. There was a mistake on the part of the counsel when placing the case. He submitted the matter you want to withdraw the matter. There is a
You want to withdraw the matter?
no, there was a he made a submission that he want to withdraw the matter and the order was passed. My lord, now there is a bar under CRPC 362. There cannot be a review of a judgment. But we are not asking for a review. This is a mistake on the part of our counsel, mistake or misunderstanding on the part of our counsel. If your lordship can restore the my lord, the criminal petition which was,
This is IA.
no, this is a new application filed. To an IA, we cannot file it, my lord.
কোনটো দিছা তুমি?
This is, my lord, 108823.
Hmm.
108823.
What was the last order?
My lord, your lordship may look into. Last page 45, your lordship will look into it.
Page?
Page 45.
Page 45.
I think it's 45.
Hmm.
That was what, my lord,
Hmm.
we have come with an inherent power before this court. Because in CRPC, there is a bar under section 362. My lord, that criminal petition or criminal order cannot be reviewed.
Hmm.
My lord, this is, we are not asking for a review.
Hmm.
Because this is, because some judgment of Supreme Court I have found, arithmetical error, rarest of rare cases, it can be
This
issued.
petition was dismissed on withdrawal.
Withdrawal. That's my only prayer was for restoration now, madam. That the criminal petition number 461 of 2017 may be restored. That,
Petition under which sections?
my lord, that was under 482, man.
482 can be dismissed.
On withdrawal. It was on withdrawal, not dismissed on withdrawal. Your lordship will find the order. It was withdrawn.
Hmm.
So that is the mistake which was done on the part of the council.
Then I cannot do anything.
Well, the bar I understand, madam. The bar is under 362. But what our prayer is that,
You
madam,
have to before appeal, I believe.
there is no appeal. We have to go for Supreme Court, madam.
You
That
have to go to the Supreme Court.
the problem is this, my lord, in one of the few judgments I found, my lord, the Supreme Court, while discussing 362 and 482,
Hmm.
they have said in some cases it can be done, my lord. Here it is, my lord, 84 SCC, page 82, para 15.
Where is the original? This is the case, no?
That was for Jimma, my lord. That was for Jimma of an elephant,
I'll have to ponder over it. I do not think I'll be able to do anything. I think you'll have to go up to Supreme Court.
My lord, we have filed it here because if your lordship can look into it and see, because the judgment is there of Supreme
Where
Court.
is the original case which was withdrawn?
That was withdrawn, my lord. I think, my lord, that was criminal petition 461 of 2017 for a Jimma of a elephant.
I think there are so many petitions being dismissed on withdrawal under section 482. Many.
But
I have dismissed so many.
my lord, there are some basic
On request
fundamental
of-
reason on request it was. My lord, that I am not saying that there is any error apparent on the face of record.
Hmm.
Nothing was there.
362, let me see 362. 362, there is one judgment also, one
Review
precedent
cannot be
also.
done. I am not asking for a review.
Hmm.
Review, my lord, if we look into order 47, that is review on the merit of the case if there is a apparent any error. Here, there nothing was decided on merit. It was just dismissed on withdrawal. Your lordship will look into CRPC 362.
And how to restore it under which provision?
My lord, just restore it. My lord, here it is said that if there is some arithmetical error and others, 482 will lie and it can be restored. My lord.
You
That
have-
judgment, that
You
2000,
have filed this petition under section 482.
482.
We usually dismiss usually we dismiss it on request by the lawyers.
Correct,
Because
correct.
on good faith, we dismiss because they want to file an appropriate petition.
My lord, here it was for Jimma.
Actually, in revision, we pass orders on merits in revision. We never dismiss it
My lord,
in revision.
my
But
lord.
482, we don't think that they can file.
I admit everything, man. The only thing is this, the bar under 362 is there in CRPC that
Yeah,
Oh.
362 is there.
court
We
not
cannot
to author
correct,
judgment. Court
except
not to,
arithmetical error, we cannot correct anything.
my lord. Here,
Yes, yes.
what we are placing that, my lord, this was a mistake on the part of the council, junior council, who made a submission that we want to withdraw that petition. Nothing was on merit, nothing was said.
Where's
Ma-
copy?
The order which was dismissed, madam.
Let us call for the original record then,
Well, original record of that original record of
which was dismissed.
461 of 2017.
Asa niki, disa niki, na dia. You have anything to enlighten us?
One thing that this order of withdrawal was on 1 December 2022.
Hmm.
This criminal
After
petition,
4 years, after 4 years.
No, it is 23.
Not 4 years,
It was filed in 2023.
but this was filed in 3/10/2023.
Hmm.
Well,
Little less than a year. But if circumstances were such that there was an unauthorized withdrawal matter, they should have been more prompt. Not wait for almost 1 year. That is one thing I would.
এইটো নেকি? কেছটো কল কৰা নাই ন? কল কৰিব লাগিব। Please read the relevant part of the judgment.
Well, paragraph 15. In view of the aforementioned specific bar, created in regard to the exercise of the jurisdiction of the High Court to review its own order, we are of the opinion that ordinarily exercise of jurisdiction under section 482 of the Code of Criminal Procedure would be unwarranted. We assume that in some rare cases, the High Court may do so where judgment has been obtained from it by practicing fraud, but it does not appear that such a case has been made out. The appellant did not make any complaint. That is done. But on merit, nothing was there. In our
So
case,
whoever is would any other court would have taken it up. It will be like reviewing my own order. Any other court or the
Because-
Supreme Court.
but sometimes because very
Because
difficult
now
for,
it is coming back to me, so it's very difficult. for me.
because that was,
Some other court's order I could have.
but because this is your lordship's order, that is why it will not go to another court. Your lordship has allowed.
But
this.
I think that this, okay. So you are asking me to review my order, not to review, but
Not to
to.
review, just to restore. Review is, if I go for order 47, review is, my lord, totally different. But in writ petition, what I understand, my lord, writ petition, that there are possibility of restoration,
Yes.
if it is withdrawn also. Because, but here,
Everywhere in civil also, everywhere.
Everywhere.
But in criminal, I don't know how to restore it.
the only bar is
That's why I'm asking you
362,
how to restore it.
my lord.
In criminal, how to restore
Because
it.
they,
If the case is filed, we can restore it, but if the case is filed,
my lord,
not dismissed, if the
Or
case is filed, we can restore it.
if it can be, my lord, only because here on merit, nothing was said, that much is there. And the merit, as it is, it was there left over. The elephant is still there in the custody of somebody,
Only paragraph 15.
15, that much. Because everywhere it is said, High Court does not have under 362 to alter or review its own judgment or order. Whether it is a judgment at all or judgment. Whether it is to withdraw the case is at all a judgment. That much your lordship has to, my lord.
I'll have to ponder over it.
Well,
I'll have to read the entire judgment. I'll have to
My lord,
ponder
and some of the judgments I am giving, my lord,
require food for thought also.
2001, 2007.
Something
I'm-
very new for me.
Well,
Maybe for the entire High Court.
Well, I am also very new about all this and inexperienced about all this, but 2001 and 2007. 2000. This all decides about. There are
Any
9 and 10
any
in.
case has been restored after that?
My lord?
Any case has been restored after that?
My lord, because it's dismissed, nothing has been done. It is lying that way. No case. Maybe this is will be the one of the first case in Guwahati High Court, my lord. Whether at all it is a judgment, my lord. Withdrawing of a case is at all a judgment. But if we look for concept of CPC, my lord, Then we can say because appeal lies in a,
But criminal, many, in criminal case, the U 362 is also itself a bar.
bar, there is a bar, that admittedly is a bar. Except to the extent of correcting any clerical or arithmetical error, that permission is given.
Yes.
Clerical or arithmetical error. Whether the council who placed the submission comes within the purview of a clerical error or arithmetical error, that much more.
Logically, I don't think so.
Becomes difficult, but your lordship will pass an order that we can, because at least we can think over. That much is the submission, nothing more. Nothing in merit. Merit that item of
Let us call for the record.
well,
Let us call for the record and then let's see.
Yes.
no, record of 461 2017.
It will come back to me.
It will come back, your lordship. Till the time your lordship.
Because what is your prayer?
Only
Let's
to-
see your prayer. It depends upon your prayer. What is your prayer?
Call for the record which was there. To show cause why the dismissing on withdrawal should not be modified, altered, withdrawn on record by the honorable court and restored the criminal petition to file and hear
That
the.
is why it has been sent back to me because there is a prayer for restoration.
Because there is nothing in other than 482 for that provision in CLPC.
Only one line. I have not written the person also who was present,
Nothing else.
and then the additional PP also who was present. Usually I write, I dictate. I don't know what prevented me from dictating that day.
Matter is dismissed or withdrawn, nothing more.
I don't think so. This is my conduct. I usually write the person who is present
But here I cannot comment.
and the additional PP who is present. Only one line. I do not think this is my conduct. And I also I have given my signature without going through it properly. In a hurry, maybe there were 100 cases. Those days I used to take up 100 cases. Maybe. So, last date this record has come to me.
My lord.
You have made the submission and then the bench thought that it must go to,
Because I am appealing for the first day today, my lord.
actually, earlier also there was a submission made before Malashri Gandhi and then she directed to list it before the appropriate bench, it came to me. Then maybe I was in Arunachal Pradesh, then it came before that bench, now it's come before me.
Whether this will be if your lordship permits me to say, if your lordship, with all humility and blessing, if I look into the order, the matter is dismissed or withdrawn, there is some kind of a clerical or arithmetical some mistake is there. Because names, nothing has been written now. Whether that will amount to of a 482 being filed before this court. Because
Don't think so. This is an order, not nothing clerical or arithmetical in it. I don't think so. I'll have to ponder over it. I'll take this home.
well, I have.
I'll take this home. This judgments, I'll read it. I'll bring it back. Meanwhile, I'll call for the LCR.
My lord.
And you also enlighten us if any order can be passed for restoration.
Criminal.
Hmm. Learned Counsel Mr. P.K. Rochelle is present for the petitioner, and Learned Counsel Mr. I. Bothago is present for Standing Counsel Forest. Learned Standing Counsel Forest, Mr. I. Bothago is present for the respondent. Call for the. Why do you want to pursue that matter which has been withdrawn?
Well, because an elephant which was minor, female elephant, which was taken in custody by somebody else and it is still alive and I want to get my elephant back, nothing more.
Is there any other way, any other
Because
way?
I filed an application for Jimma,
Uh-huh.
then it was disposed of giving it to somebody else.
Hmm.
And now it has not been properly fed up also. They are not feeding the elephant now.
So,
Either I have to go to Supreme Court
you'll
again.
have to go to Supreme Court, I think.
Or again, it will be returned back, restoring, again, it will take some time, because that much period.
I think it's better if you go to Supreme Court.
But still then, my lord, your lordship will pass an order that may help me in there. Otherwise, I have to, this delay condemnation and others are there. Your lordship has to pass an order.
Think so.
All these things will
Even rejecting it also will.
need some kind
Yes,
of
yes.
reasons to be recorded.
Hmm.
2012 8 SCC 141 para 44. Judicial orders requires reasons.
You give me what is that citation you have cited?
2012,
What is the party's name?
Union of India versus Ibrahim Ali, though it has discussed about Order 41, Rule 27 when it was taken, additional evidence. But one paragraph, para 44 has said, administrative order and judicial orders, while passing it, there should be reasons to be recorded. Otherwise, it is violates natural justice and it is no order at all. 2012, 8 SCC, page 148, I think, para 44. 141, para 44.
And any other option open for you?
Yeah, other than
Except
Supreme,
this,
there is no other option now.
but it will take some time, no?
Pardon?
Meanwhile, you are worried about the elephant.
Elephant.
It will take some time. Can't you ask for a fresh Jimma?
That aspect of the matter, if once it is rejected, how can I?
Who has rejected it?
The trial court has rejected. Trial court rejected. Trial court rejected. The trial court rejected. Trial court rejected. I have come over here. Then, my lord.
It was withdrawn. But if you seek Zimma, once the trial court rejects,
No.
if you, just I'm trying to save your time for the elephant. If you seek Zimma, trial court has rejected it.
My lord.
If you are seeking it, of course, yes. Where's the original petition? Page?
Page 11, your lordship. Which was placed before the EIS or court, your lordship.
Page 11?
11, your lordship.
There are double numbering, so I cannot find it.
Lordship, the petition, your lordship. Page number 11, petition.
11 to 9 is the petition. F1, okay.
This was the petition, your lordship, and that lordship may peruse that order that also page number 103. Whereby that's the court reference this matter to the High Court, your lordship, this court, your lordship. 103 in the last part, your lordship. Bottom, second line, your lordship. Third.
Sole contemner.
Sole contemner. Here the lordship, original content is that lordship. And PNB Bank manager issued that intimation letter to the petitioner that his bank account will be freezing. The request of that employee institutional corporation.
Taken up by this court, suo motu contempt petition.
Lordship.
It's a suo motu contempt petition.
Lordship.
Okay, we'll issue notice, but you will take direction to the registry.
Yes, lordship. Take appropriate steps, lordship. That's.
Learned Counsel, Mr. Your name?
T. Gogoi.
T. Gogoi is present for the.
On behalf of TJ.
Present on behalf of Learned Senior Counsel, Mr. TJ Mahonta. Standing counsel, no? Learned standing. Standing counsel, Mr. TJ Mahonta. full stop. Office note dated 30/1/2026 indicates that the notice issued to the sole condemner has been received back with a remark that no person named Krishna Deka is found at Punjab National Bank Silpukri branch.
Yes.
Then how can anybody issue notice if no such person is found?
Lordship, not found, your lordship, lordship may direct to the registry to take appropriate steps or impede that new incumbent. Because of that,
Registry to take steps to issue fresh notice to the sole condemner.
sole contemner.
Sole condemner properly.
Properly. That's right.
Take proper steps to
Take proper
issue
steps.
the notice to the sole condemner. Proper steps will be
Proper
better.
step or impleted that
Others
new
get
incumbent, new
association.
incumbent.
Or a new incumbent can be implemented as the sole condemner.
Lordship.
The person who has come as
Yes.
transfer.
Yes.
That will be better.
Yeah.
List after 3 weeks.
3 weeks. I'm like.
I am appearing on behalf of the respondent, Lordship. Our objection affidavit in opposition is ready, Lordship, but some time is required to file because the father of the respondent number 2 is in ICU, Lordship, in Silchar Medical College since last 1 week. So 3 weeks.
Affidavit in opposition.
Opposition. This is objection, Lordship, objection.
Objection.
We will file. 3 weeks time may be granted.
3 weeks time.
Lordship, and item number 14 is same party, Lordship.
Hmm.
If they take receipt notice behalf of the respondent, then the honorable could treat it as service complete and further proceeding, Lordship. So kindly they took, if they
This is item number 14.
14, Lordship, I will confirm through telephonic instruction, then I will receive, Lordship, just after.
Lordship, and item number 13 is a earlier interim order is there, Lordship.
Learned Counsel Ms. A. Begum is present for the petitioner, and Learned Counsel Mr. M.H.
ABT Hope.
Learned Counsel Mr. A.B.T. Hawk is present for the respondent and has prayed for time. I did not 13 to Lihiba, and has prayed for time to file objection.
Objection.
Full stop. Interim order
Lordship.
shall remain in force till the next date of listing. List the matter after 3 weeks.
After 3 weeks ended.
After 3 weeks. It is number 14 of Lihiba. Learned Counsel Mr. Miss A. Begum is present for the petitioner. Full stop. Service report on respondent is awaited.
Lordship.
List this matter after 3 weeks. Okay.
Obliged.
So placed.
I was for substitution, my lord, because that was allowed, my lord. I have filed the corrected memo also, my lord. Otherwise, matter is ready for hearing, my lord. But you may fix a date in the last week of this month, my lord. So it can be disposed of, my lord.
Oh, you have filed amended appeal memo.
Yes, my lord,
So
because,
fix it for hearing then?
yes, my lord. Already, my lord, it was fixed for hearing, but subsequently this appellant died, so his son and daughter were substituted.
Hmm.
So IA, my lord, otherwise is complied with. And my lord,
Dispose of the eye.
yes. And my lord, some urgency was there, my lord, regarding this, my lord. So somewhere in the last week of February, my lord. For a
Hearing?
Hearing.
Eye, which one can be disposed of? This one, 3394.
Yes, 3394, my lord. There was an order, my lord, a direction to file a amended plaint. We have filed it, showing the present respondent.
Learned Counsel Mr.
T.S. Hazarika.
T.S. Hazarika is present for the applicant, Ayatul Lihiba. And Learned
P.K. Goswami,
Counsel Mr. P.K. Goswami is present for the respondent. Full stop. And amended,
Amended, my lord, plaint.
an amended plaint has already been filed as per.
Appeal memo, my lord, appeal.
Amended appeal memo has already been filed
And it is tagged on record, my lord.
and has been tagged on the
Yeah.
appeal,
Yes, record, my lord.
and record, thereby this I stands disposed
Yeah.
of. RSA Learned Counsel Mr. T.H. Hazarika is present. T.H. no?
Yes, TH.
T.H. Hazarika is present for the appellant, and Learned Counsel Mr. P.K. Goswami is present for the respondent. The records are before this court. Please this matter for hearing.
Date, my lord. Any date, my lord, February last. 6 March. All right, all right. Deeply obliged, my lord.
With the lordship. Lordship, firstly, the service of notice on respond number 2. We have filed an affidavit. We took steps to dusty. It could not be served because he has changed his residence. He's Bharlumuk, but even then we could not find it. So only option left is now paper public in local newspaper. In Assamese
Assamese paper.
My lord, I have filed, my lord, an application, my lord, that is 4097. Newspaper is complete. In any local newspaper also.
I do not know whether they are Assamese or they will be Assamese. Roy.
In English in that case.
Huh? Roy.
One we have taken in Bihar, that's for the driver, that is covered, that he has completed. We have filed a paper for the driver in Bihar. But this one is in Guwahati, but even then we failed to get it.
In which one? IA or MSc?
It's admitted lordship. Appeal is already admitted.
So in the MSc, no?
Yes, lordship.
And what about the IA?
I have filed by me, my lord, to release, my lord, the deposited amount, that is 50%, 6,11,350, my lord. I am the.
You have any objection?
I have filed my objection, but same can be released subject to only point of filing this objection is that subject to indemnity bond, because I have my good grounds to believe
Yes,
it may not be RT. So subject to indemnity.
My lord, after going through the judgment, my lord, it is apparent clear, my lord, the well-established case, my lord.
So you execute one bond. You execute one bond.
Yes, I can file bond.
Yes. Learned Counsel, Mr. Ayat Liva, Mr. S. Chauhan, no?
My lord.
Objection, this is not
Learned Counsel, Mr. S. Chauhan is present for the
Applicant claimant.
claimant stroke applicant who has prayed for release of 50% of the awarded amount of rupees 611,350 by the insurance company so that he may withdraw the same. Full stop. Learned Counsel for the insurance company, Mr. R. Goswami, has raised objection. Full stop. It is submitted on behalf of the claimants that the claimant has a good case and there is every possibility to succeed in the appeal. Full stop. The claimant is the insurance company. Why you are aggrieved?
Lordship, I have given my reason. Lordship, it's a case where there is no GD entry at all. FIR was filed after 66 days. And medical documents say he fell from a height. It could have been anything. From a tree, from a house, from a something.
The insurance company has raised objection.
Now it can be released.
Considering the submissions at the bar, it appears that considering the submissions at the bar, the insurance company is directed. I've considered the submissions at the bar with circumspection. The insurance company is directed to deposit 50% of the.
Well, already deposited.
Already deposit released.
Or the claimant is allowed to withdraw the amount deposited by the insurance company. Agote deposit withdraw the amount deposited first of the prayer to all of Belek Castle. The claimant is allowed to withdraw 50% of the amount deposited by the insurance company subject to the condition that they executed indemnity bond to the satisfaction of the registry who may release the amount after proper verification. In terms of the above observation, the IS stands disposed of. MSc appeal, learned counsel Mr. R. Usami is present for the insurance company and learned counsel Mr. S. Chauhan is present for the claimant. Full stop. Office note dated 20/01/2026 indicates that the respondent number 2 could not be found in the given address. Full stop. And full stop, comma, and service report on respondent number 3 is awaited. Full stop. Notices may be served to respondent number 2 to through paper publication. By publishing the notice in through a popular news daily.
Yes.
List this matter after 4 weeks. 4 weeks?
4 weeks. 4 weeks. Plus, 26 weeks, because by the time I get this notice approved by the registry.
6 weeks?
6 weeks. It will take. I have no.
6 weeks.
Problem.
Yes, yes.
I am for stay. But problem is that the second appeal has not yet been, my lord, admitted. So, my lord, second appeal may be taken up fast. Whether any subsequent question of law is there only. Then, my lord, stay matter may be.
And second appeal has not been admitted as yet.
Not yet.
Then we'll fix it for
Order 41, my lord.
order 41 to 11.
But on urgency, the execution is going on. But short
date, yes.
on Monday, my lord, can it be?
On Monday, yes, maybe. List this matter under the column order 41 rule 11 on Monday DD. Urgency আছে বুলি কৈছে, execution আছে.
Execution has started.
List this matter for hearing on substantial question of law বুলি লিখিলে হৈ যাব. Substantial question of law. RSA টোত লিখি দিব, হা?
RS.
দুইটা Monday লিখি দিব. Monday. এইটো এখানে প্রেজেন্স টো লিখি দিয়া, learned counsel Mr. N. Hawk is present. Yes, item 18, yes.
18. This appeal is prepared by the insurance company, and today's list is passed, and there is an high court delay, continuing delay 171 days.
Issue notice. Learned counsel Mr.
A. Kakoti,
J.
A. Kakoti.
A. Kakoti is present on behalf of
Insurance company.
Oh, your name is already there.
Yes, Lord.
You are for insurance company.
Insurance.
Learned counsel Mr. A. Kakoti is present for the insurance company. Issue notice to the respondents. List after 4 weeks.
4 weeks, Lord. Same order may be passed, Lord.
Same order, item
There is a delay of 21 days.
You'll have to issue notice.
Obviously.
Lordship list is listed for the first time and there is a delay of 647 days, Lordship. I think notice will go.
Yes, learned counsel Miss R.D. Mazumdar is present for the insurance company. Issue notice, list this matter after 4 weeks.
Yes, Lordship. Steps, Lordship, will take by usual process.
Steps to be taken by usual process.
Highly obliged.
Steps may be taken by usual process.
Highly obliged.
Lordship, there has been a delay of 849 days. Lakshmi.
You'll have to issue notice, no doubt about it.
Maybe.
What is your name?
A.N. Bikosta, Lordship.
Learned Counsel Miss
A.N. Bikosta.
A.M. DeCosta is present for the applicant. Issue notice to the respondents list after 4 weeks.
Lordship, short date may be given because an execution proceeding has already been pending before the.
2 weeks? You want a date?
Yes, your Lordship.
Date
The
of the rejection?
date for the execution proceeding is Lordship 13/2. This month.
13/2. 13/2 will the notice return before 13/2? Just imagine today we are at
Lordship
Aditi
may
Pasa
also take
Iswata.
Dasti upon the sole respondent.
Okay.
Take Dasti.
On 11/2, 12/2.
Yes, sir.
List this matter on 12/2.
Should Dasti may be
Dusty service is permitted.
much obliged.
Seeing order may pass. There is an I for delay continuing.
Learned Counsel Mr. T. Kolta is present for the
176.
and Learned Counsel Mr.
Yeah,
Insurance company likhi ba, huh? And Learned Counsel Mr. A.R. Agarwal is
regarding delay, Lordship, I don't have any objection that mechanism.
okay, then we can condone the delay.
Yes, Lordship. I don't know this.
Learned Counsel Mr. T. Kolta is present for the insurance company and Learned Counsel Mr. A.R. Agarwal is present for the claimants.
Clements caveat.
Claimants and caveator, full stop. The learned counsel for the claimants has no objection if delay is condoned, full stop. It is submitted on behalf of the insurance company that the delay of how many days?
Lordship, there is an 176 day.
Delay of 176 days was not intentional, comma. There was no mala fide on the part of the petitioner, applicant, full stop. The delay was the result of the of the entire process included in the Lok Adalat, as well as the information to be forwarded to the head office, full stop. I have considered the submissions at the bar with circumspection, full stop. No mala fide is could be deciphered. No mala fide is discernible. It appears the delay may be condoned, thereby delay of 176 days is condoned. Registered to register the connected appeal.
Lordship, then next item also, Lordship.
Same.
I don't have any objection.
Same.
In Lordship, in the both the cases, my name should be entered in the time
Okay.
admission.
Etu heri eke name likhi diba, khali duita kesata likhi diba. The name of Learned Counsel Mr. A. Agarwal is to be reflected in
the at the time of admission. That will be
reflected in the cause list.
cause list. Next week, Lordship, admission next week. Admission next week, any date?
No, we'll have to register the appeal.
Register, they will admit.
No, after registering only we can give the date. Double date, not possible to give double
No,
date.
Lordship, actually, they are keeping 1 month, Lordship, for admission only.
Yes.
There are 3 months,
You'll
4
have to
months.
mention it. You'll have to mention before this court and then pursue for admission.
Lordship.
They'll register the appeal, then you have to mention.
Register and admission in the next week, like that order, that
No.
will help, Lordship.
December orders cannot be passed.
Much better.
Item number 24. I am appearing on behalf of Mr. D. Mandal. Here there is a delay of 736 days. Notice may be issued.
Learned Counsel Mr.
M. Talukdar on behalf of.
M. Talukdar is present on behalf of Learned Counsel Mr. D. Mondal. Notices to be issued. Returnable within 4 weeks. List accordingly. I to likhibo lagibo.
Steps, Lordship.
Huh?
Steps,
How do you want to take?
both ways.
Steps can be steps may be taken through speed post as well as through usual process.
Similar prayer, next item. On behalf of
Next
Mr.
item,
D.
okay.
Mandal.
Same.
26 Lordship, here I am appearing. There is a delay of 48 days. 26 Lordship.
একে ইয়াতে ডিমণ্ডল নাই খালি এয়া নিজে
তালুকদাৰ।
আছে সেম অর্ডার হিয়ারিং এনিবডি ইজ প্রেজেন্ট ফর হিয়ারিং item number 27
My lord, in the appeal, I have filed one cross objection that may be heard along with the appeal. And my lord, in the main appeal, my lord, other service complete only as per my lord office note dated
No, no,
5/9/25. Notice on the respondent number 4 is not complete, my lord.
No. But in the cross objection also, I think they'll have to take steps because the parties have to know. Some have not
Yes,
appeared,
lots
some
of-
have not appeared.
Yes, otherwise, my lord, it may be heard along with the, if
No.
lordship may please.
service is not complete
Yes,
appeal na MSC 545222
yes, my lord.
according to you service is not
No,
complete na?
office noted there, my lord, 5/9/2025.
136 file wakalatnama, 2 return with signature, 5 also signed, only for 4 lordship. That's why I was checking 4 if 4 can be struck out.
5/9/2020.
It's 4
4 is Brijesh Yadav.
what is he driver if he is
Brijesh
driver can be
Yadav.
struck off easily no role to play
He is for the national, I think, national or Harihar. Not, মানে national or গাড়ী খন। He is driver.
Driver.
He can be striked out, lordship, because
this is my judgment I think
lordship judgment.
SP count Dibrugarh district
Sorry, my lord. Sorry. At least I,
yes
yes.
SP count
Both of us are challenging in front of lordship.
We have not noticed actually.
it's okay you can challenge you'll have to challenge
Otherwise, roji roti kahan, lordship?
yes the orders can be I think I can pass I think
Perhaps it
Or
will
it's-
be better, my lord, if lordship may send it
I'll
to the
write
bench.
to
my
it
lord.
okay okay let's just matter before any other bench without me
Tell your obliged.
May I pray for a date, my lord? If possible.
why is it coming after so many years
My lord,
From 19 lordship, there was delay
delay,
petition.
then service is not complete.
after so many years
Yes, ma'am.
Yes.
by now all my appeals have been heard and finished off.
Disposed of
Yeah, other appeals, criminal.
criminal appeal.
Jail
Criminal-
appeals, basically jail appeals.
Jail appeal.
Hmm.
I've also done lordship's case. I've also done as a Micus Curie
Oh,
lordship case.
jail appeal, yes.
Jail appeal.
Most of them have been heard and disposed of. Date which date do you want?
Any date at per convenience of.
Short date এটা দি দিয়ক কাৰণ বেলেগ বেঞ্চত যাব আকৌ সাবমিশন দিব
Obliged.
Early obliged.
হে কৈ
Meet with the lordship. Meet with the lordship.
হিয়াৰিং টোহে মেইন কথা Yes,
Lordship, as per office note dated 5/2/26, Lordship. AD card of respondent number 1 dated claimant and 3 and 4 have not yet been received back. LCR has already been received.
Lordship, I am appearing for respondent number 1 and 2, Lordship. I have filed Wakalatnama.
I think have
So-
not filed, that's
Claimant?
what.
Lordship,
Claimant.
claimants, Lordship,
1 and 2, Lordship.
Okay.
1 and 2.
1 and 2. Wakalatnama is not there, I think.
Many with
It's on the way. It's maybe-
Lordship, it is in the record, Lordship. If computer, it will be seen.
So I'll list it for hearing then.
Lordship,
It's-
we have filed an application for release of the amount deposited by the insurance company.
Okay.
Miss case, Lordship, I can see.
Here, you have arrayed the driver and the.
Yes, that is not, service is not complete as per
Okay.
this Ellicott certificate may be awaited, Lordship.
MSc to likhasun, MSc, we will take up the IA case.
May be awaited.
Learned counsel Miss R. Bothakur, no?
M. Chaudhary, Lordship.
M. Chakraborty, no?
Chaudhary, Lordship.
Learned counsel Miss M. Chaudhary is present for the insurance company appeal to Likhiba, and learned counsel Mr. M. Talukdar is present for respondent number one and two. Office note dated 5/2, no? This is 5 or what? 5/2/2026 indicates that service report on respondent number 3 and 4 is awaited. Huh? 1 and 2 you have
Has not
present?
been 1, 2,
Lordship, I'm
respondent
1
3, 4.
1 and 2.
3 and 4 is awaited. List after 4 weeks. 4 weeks?
Lordship.
And I, which one?
I
you
have
present?
released, Lordship. I is there, Lordship. For release of the amount deposited by the insurance company.
Okay,
Lordship.
50%.
50% amount is 5,65,337.
Lordship, I have objection in this case, Lordship, because Lordship, we have filed the appeal, Lordship, on the ground that Lordship, the permit of the alleged offending vehicle was not there. Permit was not there because they have obtained the Lordship.
You'll file a written objection or you?
I have not filed, just today it has come. I thought that payment is not served as because his my Lanetsman Ukalatama is not there.
You want to file a written objection or you?
Or
just-
verbally, I can, if.
Yes, I'll allow indemnity bond.
Lordship.
Yes.
And if you want to file written objection, you.
I'll file,
The result.
I'll.
If it's there, I will allow it.
Lordship.
Yes, Lordship. That means valid up to 16 to 16 and accident was 25/9/16. That means there was no permit at that time. It's a public vehicle, Lordship.
There are judgments on permit.
Lordship is.
Recovery should be there. There is the observation, Lordship. There is the observation of the Lanet Tribunal that yes.
Pay and recovery, yes.
Yes, only on that, Lordship.
Pay and recovery, the tribunal will do.
Yes, tribunal only.
And they will take evidence and all.
That was not given. But observation is there. That insurance company proved its case that there was no permit at the time. But while
Not
giving,
valid permit.
while giving, awarding the compensation, that word has been missed. But observation is all same, that pay and recovery should be there. Because
I'll note it down. I'll note it down and I'll allow him to take on.
furnishing indemnity bond,
Lordship.
Lordship may give.
Learned counsel Mr. R. Chaudhary, M. Talukdar is present for the applicant, and learned counsel Ms. M. Chaudhary is present for the respondent insurance company. First of the learned counsel for the applicant has through this application prayed to withdraw the amount of rupees. Amount of rupees 5,65,337 deposited by the insurance company. Full stop. The learned counsel for the insurance company has raised objections stating that the vehicle was plying without
permit.
route permit.
Yes, Lordship.
Without valid permit.
Huh?
Without valid
Without
permit.
permit, that is
Without-
the.
Without our
valid-
permit already expired.
Without
Expired.
valid permit,
Yes.
full stop. The and has paid that the company has raised objection in.
Another ground also, Lordship.
Huh?
One more ground is there, Lordship, in the appeal, that wrong multiplier has been taken by the tribunal. That is on quantum. So far as the main is the permit.
Has thus raised objection against the release of the amount in favor of the claimant. Full stop. I have considered the submissions at the bar with circumspection. Full stop. Considering all aspects, the claimant is allowed to withdraw the amount of rupees 5,65,337 deposited before the registry of this court on execution of an indemnity bond, and after proper verification by the registry, and the amount is to be released by the insurance company. Already deposited.
Already deposited.
Already deposited.
Is to be released, Nalai already
There
deposited.
are
Already deposited by furnishing indemnity.
two claimants applicants, Lordship.
1 and 2, Lordship.
1 and 2.
Claimants will लिखी दिबा, huh? Yes. 1 and 2. 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 1 and In terms of the above observation, this application stands disposed of.
Regarding Lordship 3 and 4, service report awaited, Lordship.
Yes, yes.
Must oblige, Lordship.
After 4 weeks.
Lordship.
In 31, Lordship. Same prayer, release of the amount of rupees 7 lakh 30.
Any objection?
No objection, Lordship.
এইটো একে লিখি দিবা, ইয়াত objection নাই, একে order লিখি দিবা।
Indemnity bond is not required.
Not required.
They have challenged
Yes,
the quantum.
এই indemnity bond নালাগে।
Lordship, in the main appeal, respondent number 2, 3 and 4 can be struck off, Lordship.
Main appeal,
Yes, Lordship.
okay. Learned counsel means
MCK, Lordship.
MCK is present for the insurance company and has submitted that the names of respondent number 2, 3 and 4 may be struck off.
Yes, and to me 3, you have 5. She's appearing for respondent number 5.
Appearing for 5
So
response.
stop learned counsel.
Three, four, four.
M Chetia.
M Setia is present, both M Setia.
M Saikia, she's there.
M Soikia, M Setia. Is M Setia is present for respondent number 5. So stop the names of respondent number 2, 3 and 4 are struck up at the risk of the claimant, okay? Or at the risk of the appellant.
LCR has been received, matter may be fixed for hearing.
I'll list this matter for hearing as LCR is before us. List this matter for hearing after 4 weeks. Good. As LCR is before us, list this
Matter may
matter
be
for
listed
hearing
to
after.
the ensuing Look also. Look at the.
Yes.
Look at it. List this matter in the local alert on 14/2, no?
March.
Is there any element of supplement?
Maybe.
It can be
So,
separate, it's a
we have to
quantum.
talk, Lordship.
Yes. You have to pursue in the office. You make a pre-settlement.
Lordship,
Yes,
Lordship.
yes.
In the office, you make a pre-settlement. Appeal to kunba asa ni mata sun. Oh, appeal to hearing to.
Hearing matter, Mr. Arsipal was there,
Ah.
was sitting in the first charge.
Who are?
She's waiting for that.
Oh, he's waiting. Then I'll come back
Oblige.
Oblige,
at 2.
In this appeal, my lord, I have paid before this honorable court because, my lord, here 10,000 monthly income was there of the injured person, my lord. Subsequently, it has been calculated only 3,000 only. And 60% disability is there here, my lord, but calculated 25%.
You are the claimant.
Claimant, my lord, claimant.
MSC appeal.
MSC appeal, my lord.
You are insurance.
For
company.
enhancement.
For enhancement.
You are insurance
I
company.
mean, Oriental Insurance.
Oriental Insurance Company, my lord. But on the lower side of only it is calculated only 3,22,234. He was a motor mechanic, my lord, actually. But subsequently, in view of this accident, he 3 times, my lord, he undergone operation, my lord, in the Patna, at Patna, my lord. Subsequently, till today also, he is sick and infirm, my lord. He cannot be able to work, my lord, because of his injury of the legs, my lord.
This is MSC tribunal or labor court?
Our MSC Tribunal, Gwalpara, my lord. Member, it was passed judgment, my lord, by the Motor Accident Claim Tribunal, Gwalpara. And that is why, my lord, grounds I have stated, my lord. That is grounds are in the paragraph, my lord, can you see? Paragraph 4, my lord, page 4. First ground is, it is reducing from second ground is, my lord, 10,000 was there, only 3,000, my lord, accepted, my lord, by the learned court below. He was a motor mechanic, skillful employee, my lord, but in spite of that, 3,000 calculated, my lord. And 60%.
There is a new judgment, no?
Yes, my lord.
When this insurance company must give the salary of the skilled worker.
Yes.
You must give. If you want to prove your case, you must.
In this
And
regard,
just
How much a skilled worker earns? The minimum salary you must give.
a minimum wage act.
Minimum wage you have to prove it.
Yes. Suppose if not approved, the claimant, their income.
There's a new,
Yes.
very new judgment.
Yes.
So you must give me that. I think through affidavit or through something you have to give it. If you want
as it is case, my lord, I have given here before.
If you cannot give, then we will allow his appeal.
No, my lord, let him to argue the matter. I'll cooperate on this thing.
But I have placed the judgment, my lord, in respect of the similar case, my lord, along with the list and mark the paragraph also, my lord. That was the also, my lord, future prospect, etc., my lord, because as he is totally, my lord, unable to work, my lord.
He's a motor mechanic, a skilled labor, no?
Yes, my lord.
He's employed or self-employed?
Mechanic, my lord, mechanic.
Self-employed.
Assembly, in the garage he works, my lord. Earning
He is a
10
motor mechanic and he's working in a garage.
garage, my lord.
So he's employed,
Employee, my lord.
private employee.
Private employee, my lord.
Private garage.
Yes, my lord.
Are there any government garages?
No, no, my private, my
I
lord.
don't know.
He was given only 10,000 rupees. He is stated in my lord is witness. also.
Working in a private garage?
Yes, my lord.
Private employee.
Yes, my lord.
Any employment certificate?
No, that was not there, my lord.
This is important.
Yes, my lord. More পৰিয়ালৰ ভিতৰত একমাত্ৰ উপাৰ্জন কৰি ব্যক্তিয়ে মই দৰমহা মাহত 10,000 টকাকৈ উপাৰ্জন কৰি
No salary certificate.
no salary certificate.
No employment certificate also.
No, but that will not
That was not examined.
That will not arise
That-
because it's self-employed.
favor.
Mm.
That Supreme Court judgment is there.
Right.
It will not go in your favor. Even if he is not giving you salary, producing salary certificate,
Yes.
you have to produce the state
Yes, wages, minimum wages.
minimum wages of the
On
state
that
or the
day.
nation, national minimum wages.
Yes, madam.
But state, I think our state has a minimum wages.
Yes. There is a act also, minimum wage act. This is the WC code, labor code, this is entitled.
That
For that.
the state
Yes, state has a every year.
mentioned by the state.
Yes.
And my lord, IA also filed by me, my lord, up to date for expenditure, my lord. It is also 61,000 underground treatment. That is also added. It will be added.
You file an
Yes, already filed on, my lord, to 11/21.
I had to dia ase nahi? IA additional expenses.
Yes, my lord, additional expenditure.
IA number 4185,
Yes, my lord.
2019 on additional expenses.
Yes, my lord. It was here, my lord, amount has been calculated 61.
Disability certificate?
Disability certificate also there, my lord.
You have disability certificate? He has.
My lord, I have marked in the TCR, I have flag marked. Disability certificate and the cross examination is very important.
Okay, disability certificate.
How
Yes,
to
madam.
prove it?
You should buy a board or buy one.
Yes,
doctor.
board, my lord.
Then you don't have a good case. Insurance company.
Not board.
No board, it is there a witness box. He has stated, no? I have that question. Doctor was examined, no? I have submitted my affidavit in lieu of the examination doctor statement, my lord. In C, I was present as a member of the district standing medical board meeting held on 29/3/19 in the office premises of the Joint Director of Health Services, Gwalpara. On that day, injured Jonik Ali appeared before the board to ascertain his disability due to injury sustained. The board examined his physical condition and also scrutinized the medical documents produced by him and assessed his disability to the extent of 60%. Exhibit number 85 is the disability certificate issued by the distinct standing medical board in favor of the injured. And cross-examination right, my lord. Though I have stated in my affidavit in paragraph 3 of the exhibit 85 is a permanent disability certificate, but the word permanent disability is not mentioned in exhibit.
Then how will you get compensation if permanent disability is not mentioned?
Then that is the court is
Disability
rightly finding.
permanent.
Yes, madam. Permanent. He cannot able to.
It should be mentioned. Even the evidence also not mentioned that or permanent or temporary. This is
That's
important.
Just let me
Read it.
As per the statement of the injured, the board came to know that he sustained injuries in a road traffic accident. The board examined the injured after 1.5 years of the accident. In 85 exhibit, the age of the injuries is not mentioned. In exhibit 85 disability certificate, there is no mention regarding the treatment taken by the injured person. The board is not concerned with the treatment taken by the injured. As such, the board cannot say whether the injuries of the injured were properly diagnosed or not. If the fiction is removed, the fracture injuries may be cured or may not be. the quantum of disability may be decreased in the passage of time. As per disability certificate, the board opined that the quantum of disability is about 60%.
Disability of what?
Legs, my lord, he can legs fractured, my lord. If you say reason, my lord, he cannot be able to move, my lord. 3 times, 4 times, my lord, he has forced operation.
One leg or both the legs?
One leg, my lord, one.
There is one judgment how to calculate disability. 60% disability by the doctor of
Yes,
leg.
doctor, medical board.
Of leg. It
Yeah.
will not amount to 60% disability of the entire body. There is a judgment how to calculate disability.
Yes,
If
ma'am.
if he is a driver, then if both legs are disabled, then it is 100%
100%.
disability.
But as he is a mechanic,
Ah.
my lord, he cannot move. He cannot move now. He stopped to work there from since then, my lord, after the accident, my lord. And till today, my lord, I have told, my lord, I have told 12.5 lakhs expenditure has been done from my lord. Because of his operation, he is unable to work, my lord. And I also, I have added also those
It
certificates.
is
my lord.
difficult actually. See, it's sad, very sad. If a person is permanently disabled, it's
Disabled,
very sad.
permanently disabled.
Where is the certificate? I cannot find. I found only
My lord,
the.
in the
LCR?
LCR, my lord, I mark it.
No. In LCR, you have marked only the doctors and the evidence.
I am giving it, my lord.
Exhibit number? What is the disability?
85.
85, no?
Yes, my lord.
Red, so called red flag mark.
85, I got it. Directorate, Office of the Directorate of Health Services.
In the handwriting.
Huh?
It is in handwriting. Very interesting.
2017.
It is like a WC code. Handwriting. In the WC code, workman, the doctor is coming and giving the certificate, injury certificate, that loss of disability 40%, loss of earning capacity is 45%. So clinical examination, all the
It is
doctors in the
India
Borpeta especially giving this type of certificate, apart from any district in Assam.
2017 it was.
This
Nowadays it
Gwalpara.
cannot be. Gwalpara.
Injury, comminuted fractures, femur, internal, external. Now he is having fixation in situ. At present, he cannot or cannot walk because of fixation. Something seen disability is about 60%.
Basis, there is a no basis. Let him to argue the matter.
No, I have already.
You have good. My lord, kindly see the
Very clear.
judgment. What is the judgment of the landed court below?
This disability certificate.
Even then, my lord,
What
signature is not
disability
proof.
certificate?
Signature is not proof. Since the issuing person has come before the court, then
They
how
have
we
not
could-
cross-examined it.
No,
Or
no,
everything.
no,
No
this is
questions were put by them.
This is your
Cross-examination
document.
also there,
This
my
is
lord.
burden of you.
Next page, your lordship kindly peruse, that is cross-examination of the.
Signature of the members also not proved.
Not proved.
Yes, but that was.
It is very important. That is not a relevant document otherwise. Somebody has come, whether he has issued or not. He said he may
They have
not
not
issue.
raised any question in the cross-examination.
Question not necessary. It is apparent on the record. It is apparent from the record. It is a procedure of law. Each and every.
Signature, they ought to have proved the signature.
Yes.
Where is the judgment?
My lord, judgment is page, kindly see that page number 27.
Appeal memo.
Appeal memo, my lord, relevant, my lord, para number 6.
Page 27, yes.
Yes, my lord, paragraph 6, top. As per exhibit 85, number 85, the claimant appeared before the district standing medical board on 29/3/18 in order to assess the disability cause due to the alleged accident. The board, after due consideration of the injury sustained by him, issues the disability certificate 85, whereby declared that due to injury sustained by him caused him about 60%, about 60%, about 60%. Disability, permanent or temporary, is not mentioned. This is very important. That is the findings. This is the court. Court has some findings also. You also assess this entire things. Then 7, PWT has deposed in cross-examination that the quantum of disability may be decreased in the person in the passage of time. In the passage of time decrease.
It may increase also.
It may increase also. That question is that
May decrease.
yes, if it is a permanent, question is established. Because he is the ultimate authority. Doctor is the ultimate because we believe the doctor. I cannot believe the version of the doctor. Doctor is the ultimate because otherwise doctor is not necessary. To believe the entire thing, doctor is, that is what doctor is appear. He was called for. So the findings is very clear. Although the court is unmercifully 25% is given, not ignore entire things. Not ignore entire thing. In the two issues, this is the two issue. This is the disability certificate not established by the signatory authority. And second is that there is a no. Always, I have seen the disability nowadays in online. Nowadays, online. Online disability certificate after examination. I have gone through this joint director examination. Then they issue the online. Online. The online certificate, it is entire things also written, although it is 2017. And also provision also. This is a central provision. There is a member should be appointed by the central government. Central government, if it is orthopedic surgeon. Because if it is a, say, ortho, if it is an eye, then ophthalmology. Similarly, there is a different type of doctor. Expert doctor, they are appointed time to time, they appear in the medical board to assess the disability. This is the thing, my lord. There is a no signature, there is a no mention permanent or temporary. So what is the my lord, defective? There is a no perverse findings of this learned tribunal. No erroneous. He being the advocate, doctor, he is the ultimate authority. Because he has seen, he has examined the victim. Because he has not treated doctor. He is not a treated doctor. He is to examine the victim on the basis of the record. Board is a mallet especially appointed by the government
So
of
what
India.
was deducted? 25%?
He has given the assess that court has come to the finding 25%. Since he is a temporary, whatever it may be, 25% is entitlement. That is not wrong. Because he has not mentioned whether permanent or not. It is also mentioned by this learned court below. That whether it is permanent or temporary. Nowhere is mentioned. We also ask regarding the cross-examination. They are not mentioned. So it is very important, my lord.
That please read paragraph 8 and 9.
8 and 9, yes. From the medical evidence on record and considering the type of injury sustained by the claimant PW1, I am the view that such injuries are caused partial disability. It is not a permanent, partial. Maybe cured, which may be calculated at 25% temporary disability. Since not permanent is given, so he has as a temporary disability, not ignore entire things. So I do hold that the claimant become 25% physical disabled due to injury sustained by him in the accident. As the claimant sustained 25% disability for the aforesaid injury and for such disability, it would definitely reduce the earning capacity. 25% also earning capacity reduce automatically. I am also suffering from my leg injuries. A few days back, I could not walk, I cannot walk. But I am nowadays gradually cured.
But you are using your brains.
Yes, no,
You are not using your
There are
legs.
two things, my lord. That is a two thing. Lordship has first pointed out, suppose my leg, if it is cut down, that finish, my pain is finished. If it is me in my body, then there is a suffering. Entire body is to suffer. Entire body is to suffer. But neither I am died or I am suffering. It becomes 100%. Because if it is amputated, now finish. Pain is gone. The question is that he's suffering. Then there is a doctor said that he's amputated or whatever may be fracture like this, whatever may be, and fixation may be. Fixation, it does not mean that 100% or 40%, maybe 20%. If it is fixed, there is a femur or elbow. If
No,
there
but
is
you see here, he is a mechanic. He has to use his
no
legs.
question, I'm coming later on. He's a mechanic. If there is any document that I said this, I'm the senior advocate, and this court can, I'm the simple ground, can accept it. I may not come with that ground. He's a mechanic, simple document. Somebody has to say that he's a mechanic.
How many witnesses were given?
Only two witnesses, only one witness claiming himself and the doctor. Even then, he's a mechanic, he has his own shop, or he's
Can
working.
he disputed that he is not a mechanic? In his cross-examination?
Possibly
he-
disputed.
Not this,
Possibility, so I have not gone through that. You see.
no. Nothing, my question.
Anything, PW want to say?
Now you cannot dispute then.
No, if I not disputed, I cannot in the appeal station. Listen, I have no paper, company is always paperless. We have a very difficulties, because claimant was very much prepared. They filed this everything. It hasn't been cost to my lord. Now kindly, may I read that PW1?
PW1,
Yes, yes.
I'll read it.
Sorry, ma'am.
If you have not disputed.
I'm the my lord, Nidhiram Sardar. I have nothing. But as per my lord, paragraph 9, it is clear, the findings of the plan.
No, it is disputed. I have not submitted any
Yes.
document to prove my profession and my
Yes,
monthly
yes,
income.
it is I have not submitted. It is not a suggestion. I have not, the state were affirmative statement.
I do not remember the date in the month of.
So how I can assume that he is a mechanic, he is a thelawala, or he is an engineer? Maybe engineer. Some document has to be proved. This is your case.
Please continue reading.
Para number 9.
Para 8. You are.
8 I have completed.
No,
Regarding,
only half.
yes, from the medical evidence on record and considering the type of injury sustained by the claimant PW1, I am view that such injuries are caused partial disability and may be calculated at 25% temporary disability. So I do hold that the claimant become 25% disability, physical disabled due to injury sustained by him in the accident. As the claimant sustained 25% disability for the aforesaid injuries, and for such disability, it would definitely reduce the earning capacity. This is the earning capacity. Regarding managed income, next paragraph 9. In this case in hand, the claimant has stated that he earned rupees 10,000 as his monthly income by doing motor mechanic. But the claimant has not brought on record any kind of corroborative evidence to substantiate his monthly income. Neither monthly income nor the professional. Gabura or sometime, many things. If he's a own shop, even then he's a employee, somebody else. That is also not done. How I can believe that he's a mechanic? He's a mechanic. He may be a vegetable vendor. I'm not going to say anything negative, but it is found that no any evidence tendered by the claimant to prove that. Very specific finding. He is a technical trained skilled labor. It is to be noted that except the bare version of the claimant, there is no corroborative evidence on record to buttress his version. Under these circumstances, I do hold that monthly income of PW claimant cannot be less than 3,000 in present days. It is true that the claimant in the Motor Vehicle Act is a summary proceeding in nature and evidence should be scrutinized in a manner as it required in the civil or criminal cases. In civil cases, the rule is if not necessary, my lord. That is why I accepted 3,000 rupees. And also age also he has not submitted paragraph 10 regarding age, because for calculation of disability, age is required. Three things is required: percentage of disability, age and income, as per law. In the claim petition, age of the period has not been mentioned as 40 years, and in evidence, the age of the claimant mentioned as 41 years at the time of.
So multiply is 14 in this case.
Multiply, it will be 14. If it is, my lord,
So I don't see any infirmity in this judgment. I can only add the additional expenses through IA.
But
No
so far, my lord,
infirmity.
this 10,000 is concerned my income. Because my lord,
for the sake of convenience,
that was not objected by them.
submitting another 2,000 may be enhanced, because 3,000, he has not mentioned that I'm bachelor. He has not mentioned I have a family. In that regard, that is why I'm coming, my lord, minimum wage act. The 3,000 actually right, but for the sake of convenience, I am also giving 2,000 is award to him. Another additional 2,000, and I do not know that additional affidavit he has filed. They may be accepted. I do not know how much. Additional due to the during penalty.
It was 61,000.
61,000 plus another 2,000 may be enhanced as a income. 3,000 already there, another 2,000.
5,000.
3,000, that is 5,000 total. 25%, 14 multiplier, 5,000. Due to I have.
That skilled workers wages.
That is why the question, whether he is a skilled worker, semi-skilled worker.
Let us consider him to be a semi-skilled worker.
That is the thing.
That will be 5,000, I think.
5,000. Lumps are 5,000, more or less.
You
So
have the you have the circular.
I have to find out, my lord.
You'll have to give.
I must give. I must give tomorrow. I'll
You have
give.
to give the circular because
I'll give.
according to the new judgment, you will have to give the.
Lordship.
Similar in that respect, but I have given DRG judgment also.
Kun judgment? Kun dialog?
No.
I'll give in the Assam.
Now 5,000, 6,000, it needs to have some Roy's case, it is there, my lord.
It will be, my lord, date of accident on the
Semi-skilled is, I think, 5,000 or 6,000 like that.
2017. It will be like this because he caused injuries 2017. From 17, not today. Today it becomes not less than.
Prospect is also not calculated here.
But your ground, there is no ground.
No. That was calculated. These are all aspect in the judgment.
No, that will be added.
In ground, I have mentioned these.
And second thing is, my lord, yesterday one judgment was given, but although CAB, Justice Ravin Pokan sir. So we have made the payment, date of judgment. But if the interest, question of interest, suppose against
Future prospects.
future prospect.
No, in future prospects, you cannot give interest.
Yes.
According
In
to
future prospect,
Pranay said his
No.
judgment.
In future preferred, it is not essential money. There is
Not
only
You
that
cannot-
amount.
You cannot give
You
interest.
cannot
Only
give
two
money.
things, my lord. For
See,
me,
here you do not have a case.
otherwise.
You do not have a case otherwise. But you give me that calculation. When you'll bring the calculation?
But give me 1 week, my lord.
1
Because
week.
I have some problem in some cases in CAT also. I have to submit tomorrow itself.
That, not that calculation, that's
I'll give you that chart also.
that chart, yes.
Minimum wage act at that relevant time. I'll give.
Not relevant, then next date you have to give. Then
No. Next date I'll give.
I'll make the
Fix
pronouncement.
the date.
Huh?
I'll give.
Fix the date,
I
yeah.
furnished.
I do not have the bench, but it will come up
Sure,
before
sure.
me only.
Yes, madam, in Pathat and fix the date,
Yes.
one is after one. But up to 99, very much. I am, yesterday also I couldn't
Eh,
take it because
actually,
you.
I feel sorry for a person who may meets with an accident
Yes,
and
madam.
who cannot obtain a disability certificate also. And
Very-
look at
But
the
these are all
certificate.
technical aspect, my lord, because madam,
Certificate, not,
Yes, madam.
he's.
He
the doctor
collected,
has
but,
certificate
this-
Also whether permanent or temporary.
and that is not specifically mentioned, even the Lanet Council who was.
Not
conducting
conscious,
the case,
advocate also
he-
not
Not properly advised. Yes, my lord.
There also.
Not properly
Minimum
handled. the
standard
case.
of proof, minimum standard. I'm not
That-
going to
that
say
is not
like
It has to
civil.
be, madam, 10,000 rupees per month and 3,000 already calculated.
No, video
Another
conference
2,000
also
will get it.
Yes, sir. Maybe